Honor, why wasn't I given notice of today's court date?
Number one, you filed these motions, and this is the first opportunity that we have to hear these motions or this motion prior to your trial date. I'm assuming you don't want your trial date continued from Friday, since you had filed a speedy trial motion.
Yeah, and I'm still stating the same thing on the record, that that is not what we were supposed to go to trial on. The last time I was here, it was for the case in Dixon over with Jennifer's mom. I forget the case number. There you have the case number. She didn't speak about going to trial on this one. The state changed it without giving notice again.
I'm sorry?
I mean, it seems like it's a hindrance to my defense when I don't know what we're going to trial for when I'm coming in here, and I'm told one thing and it's another thing when I get here. And I'm not even giving notice that I'm here today. Like, I wasn't expecting to be here until Friday, and I just filed 2 more motions that would have made it on time within the time limit that's required by the local rules of practice. I got them with me. I'm kind of caught off guard here today. The reason I'm trying to get understanding.
What are those motions addressing, Mr. Vaughn?
It was another to recuse Mr. Lee Spratt, and it was another to address these charges here today too, where there was some dismissals back when I first was arrested, and them dismissals still showed up on my Homeland Security report that it caused another arrest in another county. It was a motion to arrest judgment on that. That's yeah. So I feel like I'm getting caught off guard here.
Well, your motion to dismiss or quash was filed, and this case is going to trial on Friday, so I have to hear it before the trial. To not do so would basically mean that your case would have to be continued, or you'd have to waive your motion.
No, I'm in full understanding of that. Yeah.
I'm trying to give you an opportunity to have that heard and make a ruling on the record of it so that, you preserve the issue prior to the trial date on Friday.
Okay, do you also have a motion for chief evidence up there with you?
A motion for what?
For the state's evidence in chief?
I think there is a motion such that you described, but it is not addressing this indictment number.
I should have one for all of them, and including with this, is the state not required to respond to me? Because I've responded way before the state responded. She didn't even give me a response to this motion. I'm just filing this, and
The state does not have to respond to the motion until they come to court. They can then respond on an oral argument.
And then I can have a response after that, correct?
Yeah, I'll give you a chance to respond after they do.
Okay.
But you do have a motion to preserve testimony or a motion to subpoena someone, and that is to subpoena Jennifer Dozier.
Yes.
From Savannah, Tennessee. Was there a subpoena issued for Ms. Dozier in regards to his, well, he had requested that there be a subpoena issued for Jennifer Dozier to make her testimony at the motion hearing date. All right, let's let you go ahead and argue the motions that you feel like there is a motion to preserve testimony or motion to subpoena that was filed again on July the 7th, and you've included all 3 of the case numbers on that.
You said which one was that, Your Honor?
The motion to preserve testimony or motion, and then / motion to subpoena. Then you have a matter that you filed again on July the 7th called judicial notice. And this is where you're complaining about the discovery being delivered to the jail administrator rather than sent to you directly. And then we have the motion to quash or dismiss with prejudice. I'm going to move to the Chantry docket for a moment, take up the estate of Richard Omar Myatt.
And Judge, that's just my motion for fees, supported by my affidavit, Judge.
Any objection to the fee?
Because there is not an objection, the way it was styled, we just make sure that it's not a final.
Yeah, he has a final administration CTA file fees, but
It was a typo, Judge. It's an interim fee.
I'll approve the fees having reviewed them, but again, that doesn't mean this is ending the case. So. All right.
Thank you, Your Honor.
Judge, I'm passing up a proposed order.
The estate of James Ricky Eccles.
Your Honor, received a text from Miss Jackson Smith.
Are you here?
Sorry, Judge?
Are you here physically present?
Yes.
Are you disabled?
No, Judge.
Are you unable to write your name?
Oh, sorry, Judge.
Well, I mean, you've got a proof for entry and it's got a signature / a typewritten name.
Oh,
I don't see any reason you can't sign your own name.
what happened?
And I realize that that's a bit old school, that everybody likes to do these, electronic signatures, but you're here.
I'm here.
All right, you were telling me about the estate of Ricky Eccles.
Yes, Judge. Ms. Jackson Smith sent an email to me. I believe she sent it to Ms. Hawkins by accident and intended to send it to.
Okay, you want to just pass it and reset it?
Judge, I'll pass it. We had reset this a couple of times. I understand Ms. Jackson Smith is ill. My client has taken off a few times. I would ask the court maybe if we could schedule a status conference for purpose of picking a date that'll work. We've just had trouble getting this before the court. And my client,
When do you want to set a status conference?
Judge, just at the court's convenience. And I don't know Ms. Jackson Smith's schedule, but
None of it's very convenient for me. We have, what is? October the 3rd is not. I've taken that Chancery Day away from you. Well, I'm sorry, but I've taken it away. I have assigned tentatively a PCR hearing, a post-conviction relief hearing on that day, and that's subject to change as well, depending on some things that may be necessary to change. So I would not schedule anything else on October the 3rd. Because no matter what, you're out. I'm sorry. All right. Just I have Turnbull versus Moore civil case in Humphreys County. It's a 2-day, on what? What day did you say? 27th, I'm sorry. Dixon Chancery, October 27th.
and Judge, is that for just status or is it for
Status, and then
motion?
you can set, I would assume it can be heard that day. If you want to set a status day before that, that's fine.
Judge,
too.
if we could set on that date, I'll confer with Ms. Jackson
set it
Smith
for the
and see if she's
27th.
available.
On your motion.
Thank you, Judge.
There was an order of protection that was filed in General Sessions Court in this matter that Judge Monsu signed, and there's never been a hearing on that. And so my understanding is that that order of protection would accomplish what Ms. Duke's asking for in her motion now. So rather than, and Mr. Jordan is actually in treatment. So, but I do think he's under an order to have no contact with Mrs. Jordan or the child. The order covered the child. So I'm asking that she pass her motions to your next term and give Mr. Jordan 60 days to hire new counsel for this matter. And I will do what I can do to keep her apprised of Mr. Jordan's location, which our office did for today's hearing. And that's what I'm asking.
Number one, no objection to his withdrawal. I will say that Mr. Jordan is absolutely a loose cannon, and the order of protection was the temporary order of protection was continued, and so there's a little bit of a question of the law there on whether or not it exists still. There are some bond conditions that are in effect, but I just want to protect my client. If there's any chance that he could come walking in and try to remove this child from her. I don't want that to happen.
I'm going to grant the motion to withdraw. I'm going to put an order down that grants the request for a suspension of his visitation pending a further hearing. And I do that simply because, as set forth in the pleading, he has been arrested on a number of very concerning charges in the state of Kentucky and has gone into some sort of treatment, apparently, for those things. But based on the allegations made in the sworn motion to suspend and the court's concerns that the order of protection could be argued could have expired because it was not heard. An order of protection issued by a court is valid for 15 days, and if it's not heard at that point or some other disposition is made, then it would expire under the statute. So in order to avoid any issues, I'm putting this order down that just maintains the status quo, preserves people keeping away from each other until there can be a further hearing. Now, your motion can be reset if you want, Ms. Duke, for October the 27th, if you want to set it for that day, just to have a hearing on, give him a chance to hire a lawyer.
Your Honor, I think for judicial economy, the order that I prepared does everything except for add in the language, shall be temporarily granted. So I've handwritten that in. The court wants to go ahead and get an order
Let
in.
Ms. Duke read it, and if she's in agreement, I'll sign off on it.
Yeah, I think that does that just fine, Judge. Judge, it does that. I will point out this case has been pending for about 2 years, so we do still reserve that October the 27th date. I'll do a notice resetting.
All right. Put it on October the 27th.
October 27th to 60 days.
Oh, good. I don't have to do another one.
Right.
Perfect. Yeah, that's fine.
Give him 60 days, but
That's fine.
sure.
Thank you, Judge.
You are welcome. Now, Mr. Spratt, you may go back and consult with your co-counsel, but I would suggest to you that you need to do it quickly so that we can get these officers out of here that have been subpoenaed. So,
I think we're close back there, Judge. Thank you. The arraignment, and Mr. Flanagan waived the arraignment. I just want to clarify for the record that his bond was revoked, I believe, on all these cases in July of 2024, I believe.
July 24th of 2024, the defendant failed to appear in court. Present was the DA and his attorney, Lee Spratt. Mr. Spratt spoke with the bondsman. The bondsman could not find the defendant, issued a capias and hold for a hearing. Final forfeiture was set for January 17th, 2025.
And the capias was served. I just want to make sure that, for the record, that he's never been booked on count 3, that in the event that we get to a point that he's going to get jail credits as well.
And I would only point out to you that when the indictment came forward with a third count that he had not been booked on, there was no increase in the bond. So the bond that was revoked was the same amount that was put in place at the time he was arrested on counts 1 and 2. So there was no change in the bond. And I agree there might be an argument to be made about the booking process if in fact he had been arrested on a higher bond because of that third count of the indictment.
Yes, sir. Thank you, Judge.
Then, General, you may call your witness.
State would call Sergeant Justin Stewart. Did I get it right? Sergeant.
Sergeant, if you'll come forward, we're going to put him over here.
Are you Sergeant Justin Stewart?
Yes, ma'am.
Would you spell your first and last name for the court reporter, please?
Yes, ma'am. First name Justin, Justin. Last name Stewart, Steward, David.
And Sergeant Stewart, Were you employed by the Dixon Police Department on June 18th, 2022?
Yes, ma'am.
And during that evening, did you work a call involving the defendant, Shereef Vaughn?
Yes, ma'am.
And you continued working that shift afterwards?
Correct.
And you went to the jail for another call? Or
Yes.
after another call?
A warrant service, yes, ma'am.
And at the jail later on that night after his arrest, did you encounter Mr. Vaughn again?
Yes, ma'am.
Could you explain to the court what happened?
So at the time, I can't remember if I was a field training officer or a corporal, but either way, I had a recruit with me, Officer Floyd. We made an arrest later in the shift, and while we were at the jail to deal with our arrestee, jail staff pulled Mr. Vaughn, I believe, out of the holding cell he was in, and he was upset still at that point, agitated, and he made a statement, something to the effect of, I've got bullets for all of you, or enough bullets for all of you, et cetera. So I just mentioned to Officer Javins when I returned to the police department that was worth notating in her report, just in case in the future, if she were out in public, he were to, attempt to follow up on those threats, the documentation would be there that they were made.
Nothing further, Judge.
Mr. Spratt or Mr. Vaughn, either of you have any questions for this witness? Come to the podium. And I would, again, Mr. Vaughn, I know you are pretty well acclimated to the law about a lot of things, but you must ask it in the form of a question.
Yes. Give me a second. How long ago was this case, Mr. Stewart?
2022, it's been a while.
2022. So you have full, you remember, have no problem remembering what happened?
Yes, as I said, me saying it, the phrase or the terminology of enough bullets for all of you or names on bullets or things like that, I'm not 100%. I do recall it being concerning enough that I went back and told my officer to document it just in case you actually meant it and weren't just, upset in the moment and may actually try something later.
So
right?
that's what you're standing, you're sticking to it? Like,
100%.
you're fully remembering that?
Absolutely, yeah.
Do you have any video footage of this?
So we're working on that right now. We initially thought that my video footage was tied to Officer Javin's original case with you, with the traffic stop. And then it was learned recently that, no, in fact, my footage was not from me being present for her case. It was a separate case that we had afterward while Officer Javins wasn't at the jail.
So you don't have any footage?
Of my own body cam at that time, no.
Okay. Is there any jail footage that you know of?
I'm not sure. I know, as I said, Officer Floyd was there with me, and then, of course, some of the jail staff would have been present.
Okay, and you said they pulled me out of the cell, and I made these statements?
If I'm not mistaken, I know you were standing in the area in front of what is now Male Detox 2. They have a blue square on the wall to photograph people. I don't remember if they had just pulled you out, but I remember you being out of the cell in the open there when it was set.
Okay, I rest your honor.
Yep.
Go
Have a
ahead.
moment, Your Honor.
Yeah, consult with your co-counsel.
I didn't catch your rank. Is it
Sergeant. Yes,
Sergeant
sir. That's
Stewart?
fine.
I'm sorry. I always want to clarify. You said that he was pulled out of the cell and made the statement, "I got bullets for all y'all," right? And that's exactly how he said it?
Yes, sir.
Okay. So he never mentioned Officer Javins specifically then, did he?
I don't think he explicitly stated it was her. It was
Okay.
just law enforcement.
All right. So, well, did he say law enforcement?
The only other people in there would have been law enforcement, so I just logically, yes, sir, that's who he's talking about.
All right.
Right.
But none of them are named in this indictment, correct?
I don't believe so.
Okay.
Anything else, General, for this witness?
No, Judge.
All right, thank you, sir. You may stand down.
Thank you.
All right, well, I think Trevante is lucky to have two parents who are willing to take care of him. And as Ms. Roberts and Ms. Coffinberry pointed out, since there is no property involved in this case, and his only income is Social Security, supplemental income or disability income, then there's no real, and you have to have a report, I think, annually to them instead of this court. So I am waiving the requirement of a property management plan. I'm also waiving the requirement of an annual physician's report, because obviously this is a permanent condition, so there's no reason for you to have to go back every year to a physician to get a report. So we will allow you to serve under those conditions, so. Does Ms. Coffinberry have a request for a guardian ad litem fee? You know if she has made a request?
No, Your Honor, I will check with her.
Just check with her. I think we can submit a separate order once I have her request. I just don't want to fill in an amount without her request being considered, so. All right, I've signed your order.
Thank you, Your Honor. Do we take the order now or come back for it?
Pardon?
Do we take the order now? or come back? Okay, thank you.
Good morning, Your Honor. This was our request to serve via publication. However, we've had a communication from Mr. Rodriguez, if I could pass this forward. We had no doubt as to his address, and we had to have him served through the Secretary of State. When he received our motion via regular USPS requesting the publication, he wrote back with that email. And then I responded back to him with a 50.01 service via email of the documentation. So my request to the court today would be that since he acknowledges that he knows that these proceedings are in process, he has now received a copy via certified mail and a copy via email, that we be allowed to begin our 30-day clock as to the date of the email, which was September the 23rd.
He's aware of the fact that there is a pending action, and he's suggesting that he's asking you not to post anything in the newspaper, and that he'll see you in court to send him the time and place. I think that's pretty well evident of his having acknowledged that he's been served and is aware of the proceedings, and we'll count that as service upon him. And if you want to let him know whenever you set it for a hearing, you need to make sure you send it to that same email address.
Yes, sir, absolutely.
All right, thank you.
Thank you, Your Honor. That concludes our business.
All right, thank you. Is Mr. Wambier's motion to set aside or amend or improper order and strike your attorney's fees. He's filed it.
Yes, Your Honor.
Representing himself pro se.
Yes, Your Honor. Apparently a ChatGPT or AI aficionado that he has filed this pro se.
So you're saying this is artificially intelligently drawn?
Yes, Your Honor. And Your Honor, we would proceed with, and again, just for the court to make a record, Mr. Wambier filed this petition under Rule 11 of Tennessee Rules of Civil Procedure, as well as, and filed a Rule 11 motion, as well as the motion to set aside, alleging that I had made false claims to the court. He additionally has attempted and requested copy of the transcript of the proceedings. He did not share in the per diem. I offered for him to purchase the transcript. He is under the obvious inappropriate opinion that I have an obligation to give it to him, that that's a matter of public record. So in addressing his issues, Your Honor, I would refer, Your Honor, to the hearing that took place on May 28th of 2025, wherein we proceeded on a petition to establish paternity and to adopt a parenting plan after discovery and things back and forth. Mr. Wambier appeared, and during his opening, he was pro se, and during his opening arguments, he made a number of statements which included making admissions that he had failed to pay child support. On that day, I had also served him with a petition for contempt out of juvenile court where his child support matter is pending. At the inception of the hearing, I called him as my first witness, and I asked him to be sworn in. At the time, he was sworn in, and I asked him, Mr. Warmbier, do you understand that you're under oath? Yes, ma'am. When you were giving your opening argument to the judge, you were not under oath. Okay. So that you now understand that you're sworn to tell the truth. That's correct. And the answer is that's correct. And you understand that the statements that you made before the court in your opening arguments, will you affirm that all those were true? Yes, I would like to. So I don't commit perjury. December of last year, I was allowed to visit the children for 30 to 45 minutes. That was the only time that I saw the children. It was something that I did forget to mention in opening statement. Other than that, all else remains true. Question, so you're admitting that you were significantly behind in child support? Yes, ma'am. You are admitting that you knew willfully, that you are willfully behind in child support, that you knew you owed that obligation, correct? Yes. And that you used the child support as a weapon, basically, against Ms. Whitworth to try to get some type of agreement on visitation, is that correct? Weapon is a strong word. Well, what word are you going to use? I'm sticking with leverage. Question, leverage, okay. But you're stating under oath that you willfully withheld paying child support and that you used it as leverage against Ms. Whitworth, correct? I did, yes. And you understand you were served with a petition for contempt of court for failing to pay child support? Yes. Did you have an opportunity to read that petition? I was able to glance over it. And you understand the statements before this court, there's a court reporter, and everything that you say under oath has been true and correct? Yes. We then proceeded and had a hearing wherein I called my client, Mrs. Whitworth, who put on testimony. And then Mr. Warmbier then stood up before the court. Your Honor, after hearing what was just stated, I told him to go up to the podium. Oh, I'm sorry. And he said, I was taking those moments as a reflective period. A lot of what she read out, that was very true. I said some nasty, heinous things. I didn't do right. I'm willing to accept the proposal that they're given, that we can. And you said, all right, Ms. Roberts, it appears he's willing to accept your proposal. So if you're willing to submit your proposal in written form, then we'll go from there. Thank you, Your Honor. And so what I did, Your Honor, is I prepared an order from the 28th day of May of 2025. And I stated in there that Mr. Warmbier was appearing pro se at the conclusion of the testimony and other proof offered by the plaintiff in her case in chief. The respondent, after being duly sworn, announced that he acknowledged that his behavior had not been in the children's best interest and that he agreed and stipulated on the record that the permanent parenting plan offered by the petitioner was in the best interest of the minor children. Respondent further acknowledged under oath that he failed to make timely payments of his support obligation and that he had the ability to make such payments and withheld paying the funds to the petitioner in retaliation of her not complying with his demands. He testified that his actions were not appropriate and he regretted his actions. Based on the proof and stipulation, the court finds the plan tendered by the petitioner mother in the children's best interest. I adopted the plan and I entered a judgment because he consented and I asked for attorney's fees. I charged Ms. Whitworth a flat fee of $5,000 and I entered a judgment for that $5,000. And that's the order that he is attempting to set aside and state that I made false claims and ask for Rule 11 sanctions against me. And I would ask that the court make an affirmative finding that the order is true and correct and that the Rule 11 sanction is not inappropriate.
I'm familiar with the proceedings that took place in this case, and I signed the order because I thought that the order affirmatively reflected the announcement that was made that day and the evidence that was offered at the trial. And for that reason, I find that the order that was entered and the one that Mr. Warmbier is seeking to overturn is the appropriate order and that his motion is not well taken and that there was no violation of Rule 11 sanctions. If any violation of Rule 11 occurred, it was by Mr. Warmbier rather than Ms. Roberts. So, Mr. Warmbier's motion is denied and you may draft an order accordingly.
Thank you, Your Honor.
Not actually sure how the court wants to take up. I've got 2 red wells full of the various pleadings Ms. Perricone has
Well,
filed.
the first issue is that Ms. Perricone had filed a motion to be allowed to testify in this proceeding via remotely by audiovisual means, and she filed that under Rule 43.01 of the Tennessee Rules of Civil Procedure. So I need to first address that issue because obviously these are substantive motions that she's filed, and then you have also filed a substantive motion, and the court needs to address whether or not she's going to be allowed to present testimony and so forth under Rule 43.01, or whether or not she's going to have to appear in person. So if you allow me to let Ms. Perricone go ahead and make that statement, let me first observe, Ms. Perricone, that your motion that was set yesterday, there was some confusion about it. I have reviewed your motion to allow you to testify remotely under 43.01, and I'm willing to let you tell me why you feel that it's necessary for you to appear under those conditions.
Thank you, Your Honor. Yesterday I was present at 9 and then 10:30, so I do appreciate you giving me the chance to speak. It's a hardship just due to the distance and the short amount of time there, and obviously having a 3-year-old, and it would be obviously very much appreciated if I could appear remotely. I can obviously have a quiet place just like I do now and make sure that all of the rules are followed. So that's pretty much what I have to state on that.
Well, first of all, let me tell you that if you had reviewed the rule that you had filed your motion under 43.01, a motion for permission to present testimony by audio-visual means must be filed at least 60 days before the hearing or trial which the party seeks permission to present testimony. And that gives any party, such as Mr. Davis and Mr. Baker, the right under that rule to object in writing 10 days after the service of the notice of the motion. Your motion was filed according to our court file, it was filed last Friday, the 12th, and therefore it doesn't comply with the time limit that the rule provides. Second is, and this is more salient, the motions that you have filed or have been filed on your behalf allege various procedural defaults and constitutional claims arising from different issues that you claim, which are at length citing various constitutional issues and, for example, declaratory claims under Tennessee Code annotated 36.8, so forth. A verified motion to enjoin unilateral medical decisions, preserve the children's religious and constitutional rights. Motion for reconsideration of an order granting the respondent's motion to compel. A motion for dismissal of our guardian ad litem. Who is the guardian ad litem?
Ms. Furlong Smith, and she's on a Zoom just outside the courtroom. I think she'll be in shortly.
Okay.
Judge, with the court's permission, I'm Ms. Smith, she is on the Zoom call in another matter.
All right.
So with the court's permission, I'll be taking that.
All right, and my point of that is that under that rule that you have cited, there's an order for remote testimony by audiovisual transmission. The court may enter an order permitting the presentation of testimony by audiovisual means as follows. For non-party or lay witnesses, upon a finding that good cause exists for accepting the testimony of audiovisual transmission. That's a very low burden, just requires good cause. However, where it's a party or an expert witness, upon a finding that with due regard for the importance of presenting testimony through witnesses physically present in the courtroom, exceptional circumstances warrant receiving the testimony of a party or expert witness by audiovisual transmission in the interest of justice. And in this case, based on all of the allegations that have been made, and my review of the various pleadings that you have filed leads me to question whether or not these pleadings are actually drafted by you or by some other person, and whether or not they represent your own personal argument, or if you are utilizing some other person, either an artificial intelligence or something else. And for all those reasons, I have considered your request to testify remotely, and I must deny your request. In view of that fact, I will allow you to reschedule your motions to be heard when you can actually appear in the state of Tennessee, rather than take them up because you cannot present your testimony remotely. That would be my ruling in this matter as far as her motion goes. And in fairness to Ms. Perricone, I would give her an opportunity to be present. Again, we can reset these motions for October the 27th. Is that the day I gave you?
Therein lies the rub, Your Honor. Let's see.
Well, I have another day of, no, that is the next Chancery Day after this month, right?
I am unavailable on,
You are?
unavailable on the 27th. I'll be in depositions that day.
What about the 31st, Halloween?
How fitting. I'll be here with costume and all.
All right, Ms. Perricone, I can reset all of these for October the 31st to give you ample time to make your to travel here for the court appearance, okay?
Okay, thank you, Your Honor.
Everything will be reset for that day, October 31st.
Yeah, maybe we should check with the GAO real quick, Your Honor. She may have a costume party to attend.
The guardian ad litem stand-in was uncharacteristically quiet at the moment, so I have forgotten.
She was doing her best Mickey Furlong Smith impression. And just to clarify, that includes Father's Rule 11 motion
Yes,
as well. Okay.
your motions to dismiss and rule out is under Rule 11.
Thank you, Your Honor. Get out of here before the court appoints me to a case.
Do what?
I'm gonna get out of here before you appoint me to another
Well,
case.
let's don't leave too quickly, because we got to make sure that, and we had criminal mixed in with civil yesterday, Mr. Davis. We could have given you some more work if you wanted. All right, I've reviewed the file and we are ready to go, so you may call your first witness. All right, and this, are we having this child testify in open court, or are we going to do it in chambers? I prefer not to hear from children, period, put them in the middle, but I also know that factually sometimes there's no way around that. And the other preference I have is that if we're going to hear from children, we do it in the chambers across the hallway from the jury room, but that would depend on if both sides agree on that. So, Mr. Baker, do you have any opposition to having a child testify in chambers? Both the lawyers will be present? All right, then we'll bring the child in and have her testify. We're going to go across the hallway and we'll hear from her in chambers. You say December? Well, let me say this to the parties. Your daughter is obviously, I hate hearing from children in chambers. That's one of the things I hate the most, but sometimes it's a necessary thing. But your daughter has been very emotional this morning when she talked with me and described some of the issues that she saw. Clearly, we can continue with the hearing, but I think it's wise that your lawyers have arrived at the agreement that pretty much mimics what I was going to do, at least where I was in my thinking. And that is, there's been some allegation of drug use, so we're going to order that both of you submit to a hair follicle extended panel, what you want, pardon me, an extended panel hair follicle test. And then we're going to appoint a guardian ad litem for the benefit of your children, because you have 3 children, if I'm understanding correctly, and the oldest child has pretty strong preferences to what she wants. The other two are below the age where the court is required to consider their wishes. But I also hesitate to separate children, but we are going to go ahead and continue that the daughter will remain with the father, and the other two children will resume their week on, week off with the mom until we can get something else done. So let's appoint, who do you have in mind to appoint the guardian ad litem? Ms. Smith is, I just don't know that she's covered up, but, if she has the availability, she would be my preference, but you have someone else in mind? Lynn Coffinberry is often, let's appoint Lynn Coffinberry, who is probably a little more available. She'll be the guardian ad litem. The Rule 35 evaluation is based upon the fact that the pleadings in this case and the testimony that I've heard indicate that there is a cause for concern regarding the behavior, at least of the mom, and so we want to go ahead and eliminate any issues that might result from that, and we'll have a Rule 35 evaluation to make sure there's no outstanding issues, and then from that, having appointed a guardian ad litem, and I would think that if nothing else, we need to start family counseling for all of the children, but also especially with the mom and this oldest daughter, because there are some issues. And it's not unusual for Amber to have some issues where she's going back and forth and she likes one house more than the other. I just want to make sure there's not something else more pressing that would be an issue. And with that being the case, looking at the month of December when you're talking about setting it, did I give you any December dates? The what? I have criminal trials. How about the 5th of December? That's Judge Turnbow, which you want him to hear the case, that's fine too. She wants December the 5th for a chancery day. So.
Looks like a good day.
All right.
We can make 12/5 work, sure.
December the 5th will now be a Dixon Chancery Day, and you can set this case on the docket for review. It's hard to raise children when you're divorced and you're going back and they go back and forth. It really requires for this equal residential schedule to work, parties to communicate as well as possible. Sometimes that's not possible when parties have gone through a divorce or a child custody situation in the past. I hope whatever the problem has been will be alleviated by the counseling and the things that we're doing here today, and that the children need both of you in their lives. Right now, Amber is upset and she wants to stay primarily with her dad, but as a practical matter, she also wants to see you and to have an opportunity to do that. And I think that counseling with you and her can help overcome a lot of those issues. So the ideal situation is, let's make sure we're not talking, and this order needs to contain a prohibition against either of them making derogatory remarks to the children about the other parent, or if there are significant others in the other, if you have someone in your life and you've remarried, right? Then let's include that to prohibit any negative remarks about the other significant others in the parents' lives. So, anything else we need to address?
Oh, Your Honor. No, I think that's it.
Who's drawing the order?
Be glad to.
All right.
I'll circulate it, make sure everything's.
Thank you.
Thank you, Your Honor.
All right, that concludes our business for today then, and we stand adjourned.
All right, let's talk about that. Watching work through this session was like watching someone juggle a legal seminar, family drama, and a criminal hearing all in the same hour. Steady, probing, and unwilling to let details slide. The morning opened with representing himself pro se and arguing motions before trial. He complained of surprise hearings, missing discovery, and filed motions to quash, dismiss, and even recuse prosecutors. Wolfe listened, but explained that the court wasn't ambushing him. Motions had to be heard before Friday's trial to preserve the record. He reminded Vaughn that the state doesn't have to file written responses and that oral argument in court is enough. Wolfe gave him space to be heard, but made sure the process stayed on track. He then called Sergeant Justin Stewart, who testified that after Vaughn's arrest in 2022, he threatened jail staff and officers, saying he had bullets for all of you. Stewart admitted he couldn't recall the exact phrasing, but was clear it was concerning enough to document. Vaughn cross-examined personally, pressing about memory lapses and whether video existed. Wolfe stepped in at times to remind him that questions, not arguments, were required. The testimony hung in the balance of credibility, officer memory against a pro se defendant's skepticism. From that, shifted into civil chancery matters. Wolfe approved fees in an estate case, dealt with service issues in another, and clarified technical bond and booking issues for a defendant with multiple counts. The variety underscored how quickly the court pivots between probate, family, and criminal law. One of the more star involved a pro se litigant accused of using ChatGPT to draft filings, with opposing counsel pointing out artificially intelligent language in his Rule 11 motion. Wolfe listened, reviewed the history, including the man's sworn admissions of using child support as leverage against the mother, and firmly denied the motion to set aside prior orders. His tone was calm but decisive. The record spoke louder than creative pleadings. The session also touched on Cuss, with Wolfe appointing a guardian ad litem, ordering counseling, and requiring both parents to avoid derogatory remarks in front of their children. He laid down rules for hair follicle testing and evaluations, showing his concern that parenting disputes not devolve into open warfare. His approach was pragmatic. Stabilize the children's lives while the legal wrangling plays out. What tied it all together was Wolfe's balinfendants and pro se parties' air grievances, but he kept the focus tight. He listened to police testimony, pressed lawyers on scheduling, and dealt with family disputes with equal steadiness. Humor crept in occasionally, jokes about Halloween hearings and Mickey impressions from counsel, but the core was consistent. Clarity, control, and a reminder that court is about facts and procedure, not theatrics. If you found this hearing insightful, consider subscribing, hitting the bell,